The Shepherd Law Firm has a long history with Shell Point. It was interesting, just this last week, I saw John Shepherd in the community, and he said, someday, let's you and I go to lunch, and I'll tell you about the conversation that I had before Shell Point existed. And that's how far back some of these relationships go. Obviously, Craig Hirsch and Michael Hill were not practicing law in those days, but they have also continued that friendship with Shell Point. They've been out here many, many times, have shared important things with us, and our attendance today obviously underscores how much you appreciate that. Let's welcome them as they come and share with us today.
Thank you, Tim, and thank you and the Legacy Foundation for having Mike Hill and I. And for those of you who don't know me, I know there's a lot of familiar faces in the audience today. My name is Craig Hirsch, and I'm a board-certified wills, trust, and estates attorney with Shepherd, Brett, Stewart, Hirsch, Kinsey, and Hill. And as Tim alluded to, our firm has been representing clients here in Fort Myers since 1924. So I think I look amazingly well for having practiced that long. But what we're going to talk about today, what Mike Hill, who's also, by the way, board certified in wills, trust, and estates, what Mike Hill and I are going to talk to you about today is legal matters when a loved one dies. And we understand and know that that is a very trying time when that happens. And what our goal today is to try to give you and your family, and as you can see, we're videotaping this. And the reason we're videotaping this is because this might be information that your family might need one day. So when something happens, we'll be able to send them this DVD and say, here, watch this, and then we can talk about the particulars of your situation. So there's a lot that has to happen when someone passes as far as legally, either a will, through a probate, or a trust administration. And Mike and I are going to try to cover some of those things. But as you know, nothing's more stressful than when someone dies. You know, attorneys ask you to sign papers, accountants ask you to sign tax returns, and financial planners have their things that they need you to sign. So we understand that you're vulnerable at this time, and you have a lot of questions. So you have to be careful that you're not making bad decisions. But with that said, you know, whoever is going to be acting as your personal representative, that's like your executor under your will, or as your trustee, they need to know that there's things that they have to do and how they have to do them. Now, typically they'll hire the firm that helped you create your will and trust to administer it, but they need to know that they need to act and that there are time deadlines that they need to act under, both legal and tax. So it's a good thing to, you know, you don't have to go running to the lawyer's office the next day after somebody passes, but it's not a bad idea to do it within the first few weeks, or at least have a telephone conversation. So today we're going to review those common questions and issues that confront the families when a loved one passes. So let's talk about the topics that we're going to try to cover today. We're going to tell you, and by the way, as Tim mentioned, all of you have copies of these slides. I know some of you are in positions in the room that you cannot see the slides very easily. So right now we're on today's topics. It's on the next page, second page. So what we're going to try to talk about today is what is a probate administration, what's a trust administration, what's the difference between the two, what are the duties of someone who's going to serve as your personal representative or as your trustee, how much time should it take, what about beneficiary distribution issues? Sometimes it's outright, sometimes it's in a continuing trust. And then what about those assets outside of an administration? We're going to talk to you about that. What does that mean? So at this point, I'm going to turn it over to Mike Hill, who's going to talk about wills and probate.
Thanks, Craig. Can everybody hear me okay? All right. So, like Craig said, again, my name is Mike Hill. I'm also board-certified wills, trust, and estates attorney, for those of you who aren't familiar with me. Let's talk about wills and probate. What exactly does the probate process look like? Well, whenever we have a will, one of the biggest myths that we hear a lot is, I've got a will so I don't go through probate, right? No, not the case at all. When we have a will, it's actually going to require the probate process, and this is what it looks like. First off, the last will is admitted to the court. We deposit the will with the court, and the court, probate is nothing more than proving the last will is the decedent's, the person who's passed away, their wishes. So as you might imagine, sometimes we've got amendments or codicils to our will. A lot of times we did a will back 10, 15 years ago, and we've got a new one. So the probate process in a nutshell is making sure that the will that is admitted is truly the last will of the decedent, and that it is his or her wishes. The next step is the court appoints the personal representative, also called the executor. Here in Florida, we call it personal representative. They're appointed, and they're the ones that are in charge of the next step of gathering the assets, valuing the assets, and managing the assets. We call this marshaling the assets. They gather and they collect everything so they've got a good handle on everything that's owned by the estate. The next step is all the beneficiaries are notified. So we notify the beneficiaries of the will. We tell them the contents of the will. We also notify who's been appointed personal representative, so they know who to talk to, they know who to contact. After that, creditors are notified. We need to make sure that all of our debts are paid. So we've got funeral expenses, and most of the time we don't really have creditors for most of our clients, but we've got doctor bills and ambulance bills and funeral bills. Sometimes we've got some credit card things that are lingering out there. But creditors are notified and cleared, and this is a key that we're going to be talking about over the next several minutes. All of the creditors, all the potential creditors that we may owe money to, they're gone after 3 months. After 90 days, if we do everything properly, no more creditor can come forward. And that'll be something that we really talk about in the trust side in a minute. After that, we account, the duty to account and provide accountings to all the beneficiaries. The personal representative has to say, this is how much assets I had, step number 3. This is how many bills I paid. This is what the distributions that I made. And here's what I have left to pay to the beneficiaries. Okay, so that's a formal process, and it's not just a simple accounting like a tax accounting where we pay your taxes. This is a principal and income accounting, and we'll hit on that in a little bit. Tax returns are filed. Make sure that we pay all of our taxes, income taxes, estate taxes, capital gains taxes. Finally, we make distributions to the beneficiaries, and then we close out the estate. Okay, that's kind of the probate process in a nutshell. Right. And also that's very, the court is involved in every single one of those steps. Every single time we have to notify the court, then notify the beneficiary, and the court signs off all along the way. If we could hold questions to the end, let's get through this, and then we'll take questions for about 15 minutes. Okay, so what does the trust administration process look like? Well, let's take a look at the steps here. Well, we've got the trust notice is filed and circulated. Basically, what the trust notice is hey, there is a trust that's in existence. It puts everybody on notice that the person had a trust. The trustee accepts. The trustee who is named, the next trustee after the person who's passed away, they accept because there's a lot of duties and responsibilities, as we'll talk about, and they've got to knowingly accept those. They gather the assets, value them, and manage them, basically marshaling all of the trust assets. They notify the beneficiaries. Creditors can be notified and cleared. There's an asterisk on that. That's an option and one of the things that Craig's going to talk about in a minute. Trustee still has to account to the beneficiaries. We file tax returns. We make distribution. And finally, we close out all of the trusts. Now, this slide looks very, very similar to the last slide, doesn't it? What's the one thing that's missing, though? The court, the government. That's exactly right. See up at the top, trust administration is a private process. It is a private administration. We still have to pay your creditors. We still got to make sure all the I's are dotted, all the T's are crossed. We still have several things that the state says that we have to do. We're just not at the mercy of the probate court. We don't have to wait for them to do anything. It's a private administration. And by that, we mean we're saving time. It's a much more efficient process. We're saving professional fees. We're saving court costs. Okay? Now, on the probate side, do we need a lawyer? Yes, we do. Florida law requires that a lawyer be appointed to represent the personal representative. Now, if the personal representative happens to also be a lawyer, some of our clients' children are practicing attorneys, then they can serve in both roles there. But yes, they have to be represented by an attorney. Also, a lot of times I get the question, well, I've only got, a couple $1,000. I don't need a probate, right? I've got $50,000. Well, no, that's not really true. If we have any assets in our name individually, we have a probate process. Now, what they're really getting to is what about this summary abbreviated probate? There is a what we call a quickie probate. It's called a summary administration, and it takes a lot of the red tape out of the equation. We don't have to worry as much about creditors, and we don't have to do accountings and all these other steps. But that's for folks that have less than $75,000. Okay, so every now and then we've got the folks that have maybe a homestead and then just a couple small bank accounts. And we can go through the summary administration. But there are issues with the summary administration because back to the creditors paid and cleared, if we don't have any creditors, that's when a summary administration can really apply. And if we have less than $75,000 and no creditors, we can go through the quickie probate. Okay. Also with homestead, if we have a Florida homestead, in order to pass that on to our children, one of the nice things about homestead is we can pass that free of any expenses. Okay, so free of any creditors, except for something like the mortgage or a federal tax lien. But if I've got a big homestead and I've got a bunch of credit card bills or medical bills, the homestead's going to can pass down to the kids outside of those bills, outside of those expenses. It's one of our protected assets. But in order to do that, we have to deal with the probate court. We've got to go through the court system and get what's called an order determining homestead, and that will pass it free and clear of all of those claims. Now, if we have co-owned husband and wife, tenants by the entirety ownership with our homestead, we don't have to worry about any of that. So typically that's not a problem in a married situation, but whenever we pass it down to the kids or to the grandkids, to our next beneficiaries, a lot of times we've got to go through this homestead order if we're concerned about creditors. Now, great question. Where are the assets probated? We have what we call domiciliary probate administration. That's where we're domiciled, where our residence is. And for most of our clients and most of us, it's going to be in Florida. This is where we live. This is where our homestead is. But what if we own assets outside of Florida, outside of the state of Florida? Okay, first off, the last one here, stocks, bonds, brokerage accounts, bank accounts. If I've got assets in the Bank of New York, for example, and they don't have a Florida branch, it's what we call personal property. And those types of assets, stocks, bonds, CDs, those are all in my home state. Those are all probated here in Florida. We don't have to go to New York or to Pennsylvania or to Ohio where you have those types of assets. The kicker, though, is the real property. If I own real estate in another state, okay, not only do I have a Florida probate, Florida administration, I also have the out-of-state probate. Okay, it's called an ancillary administration. And so, as you might imagine, anytime I sit down with a client, we've got property in Florida, some in North Carolina, some in Pennsylvania, some in Ohio. It's a clear case to set up a trust to avoid probate in all of those situations. Because if we keep it in our individual name or even joint name with the spouse, not only do we have a Florida probate when they're both gone, we've also got a North Carolina probate, a New York probate, a Pennsylvania probate. So we could end up with many probates across all kinds of states if we don't plan properly. I'll turn it back over to Craig.
Okay, so now that you understand what probate means, has everybody got that down? When is probate not necessary? Well, when we have no assets in the individual named of you, of the deceased. When Craig Hirsch dies, if he has a certificate of deposit in the name of Craig Hirsch, subject to probate. If I have it jointly held with my wife, Craig and Patty Hirsch, joint with rights of survivorship, not subject to probate because it's going to go to Patty at my death. If I have it in TOD or POD to somebody, not going to be subject to probate. if I have an individual retirement account that names a beneficiary, or a life insurance policy or an annuity that name a beneficiary, not subject to probate. And there are certain assets that are exempt, like your car. You don't need to worry about your car. Now, what do I do with that certificate of deposit that's just in my name? What should I do? Should I transfer the asset before I die to make sure that it's not subject to probate? Well, generally speaking, I should, right? If I have a revocable living trust, it's a good idea to transfer the asset from Craig Hirsch to the Craig Hirsch Revocable Trust. That way it avoids the probate process. But what about putting it in pay on death or joint with rights of survivorship? Well, there's a whole issues with that. Many of you were here 2 years ago. How many of you were here 2 years ago when Tim and I talked about the perils of joint accounts? Yeah, many of you were here. But if you weren't here, you want a reminder about why the joint account idea is not so great, or the POD. We have a DVD for you because we filmed it. And if you want it, just fill out the yellow evaluation form. You have both a yellow evaluation form from us, and you have a green evaluation form from Tim and the Legacy Foundation. If you don't mind, when you fill out the yellow one and give it to one of my gals at the end, they will give you this if you want it, the perils of joint accounts, because we don't have enough time to talk about that today. So you have to be very, very careful, though. I'm just going to give you a brief summary of why you don't want to transfer something in joint account. If I had, let's say, a $250,000 brokerage account, and I put it half and half with my daughter, Gabby, joint with rights of survivorship, what did I just do?
A gift.
That's right, I made a gift of how much? $125,000, right? How much can I give Gabby tax-free without having to file a gift tax return? $13,000. Smart group here. Really, you guys are really up on it. $13,000. So I have to file a gift tax return, eating into my gift tax exemption. What else have I done? What happens when I die? If I own, let's say, Coca-Cola stock at $1 a share, and it's now worth $10 a share. And when I die, what do my kids inherit it at? They get a step up in tax cost basis to $10 a share. So if my kids sell it the day after I die, what happens? No capital gain, right? As opposed to if I sold it the day before I died, I'd recognize capital gain, right? But when I make a gift, what happens? She takes the same tax cost basis I had, right? You lose the step up. I have 3 daughters. So let's say I put everything in joint name with one because I want her to write the checks and pay the bills. Do the other 2 share when I die? No. What happens if Gabby's getting divorced? And her husband wants half of everything she owns. Does my account count? Possibly, yep. That's just a primer. Watch a DVD to get everything else. So if I convince you all not to put everything in joint name, for the most part, you also defeat the tax planning in your trusts that many of you have. And let's talk about that next. This is the typical tax planning for a married client. And for those of you following along on the sheets, it's on page 4, and it's the second slide that has the graphics on it. And just briefly to illustrate this, when we have a husband and wife, spouses, and one of them dies, typically there's up to 2 subtrusts, or maybe even more, created at your death. You'll see a family trust and a marital trust. The family trust is also called a bypass trust. Sometimes they're called AB trusts. But what's important to know is that these trusts everything doesn't get distributed to the surviving spouse, right? It's held in the decedent spouse's trust. Why? Why? Because we don't want it all taxed in the surviving spouse's estate. That's why husband and wives have 2 trusts, and we divide the assets. Now, the new tax law does something called a deceased spouse use of their credit, but that's only good for the next 2 years as far as we know. For those of you, by the way, who want to know about this new tax law that's just passed, we're putting on a workshop for clients and guests. You'll see a handout in your brochure about those. So if you want to learn about the new tax law, we're doing another workshop in a few weeks. But in any event, we have husband's trust and wife's trusts. They don't collapse into one at the first spouse's death. They continue on for the surviving spouse. Oftentimes, the surviving spouse is also the trustee of the decedent spouse's trust. Now, with that said, do you see those two little boxes, family trust and marital trust? One of the things that we work with the families is we have to decide what assets are going into the family trust and what assets are going into the marital trust. And from where are creditors paid and where are taxes paid and all those sorts of things. So that's part of the administrative process. That's what your trustee is going to be responsible for, whether it's your surviving spouse or one of your children or some other person. Now, when we have just a single client, what happens? A little less complicated. We still have to do all the things that Mike mentioned a few moments ago, clearing the creditors, doing accountings, filing tax returns. But we have to oftentimes divide things. Sometimes you have continuing trusts for your children, so we have to fund those trusts as well. So let's talk for a moment, going back to a probate. What are the personal representative's duties? What are they responsible for? What's your executor responsible for? They have to carry out all of the duties of the estate, marshaling the assets, doing everything in that 9-point checklist. Your personal representative, believe it or not, is personally liable under the law to your creditors, taxing authorities, and beneficiaries. What does that mean? If they just make willy-nilly distributions and it turns out that there's another creditor out there that they didn't clear, who has to pay for it? Yeah, your personal representative does. What if they've already made distribution? Too bad. It comes out of their pocket, doesn't it? So they can go back to the beneficiary and say, please cough up another $3,000. There's a $9,000 bill out there, and there's 3 beneficiaries, and we need the money back. Good luck, right? Oh, I spent it. I'm so sorry. Now, during the administrative process, the personal representative must act as a prudent investor. There's actually a Florida statute on point. If you care to look it up, it's 518.11. What does that mean? What happens to your assets every day as we look at the stock market? They go down. Yeah, they do, don't they? They go down. They go up and down, hopefully. And the stock market's kind of risky, isn't it? Yeah, I think so. The older I get, the more riskier I think it is. But if you're the personal representative and you're in a short time frame, aren't you? You're only going to be managing these assets from the date of death to the time of distribution, right? Right? Okay. Is it wise to stay in the stock market in that short period of time? No. What could happen? Let me give you an example. The IRS values our assets on the date of our death and assesses tax based on the value of the date of death. Let's say the day before we distribute, the assets fall 40%. There's a crash. Right? Let's assume that. Are we paying tax on this lesser value? No. No, Uncle Sam wants the value on the date of your death. There is an alternate valuation date 6 months later. There's always exceptions, isn't there? Lawyers always come up with exceptions, but let's just use this as an example. Date of death value, tax-based, assets fall. Is your personal representative acting as a prudent investor? No. In a short-term window, generally speaking, you're going to want to liquidate those highly volatile assets. Remember, you got to step up in basis, right? You got to step up in tax cost basis, so there's no capital gain on that transaction, generally speaking, under today's law. So there's no risk. So why not get it into something less volatile during the administrative period, and then when you make distribution, the beneficiaries can go and invest in what they want. Now, what about a trustee? Remember, trustee looks a lot similar to personal representative, don't they? The trustee is the person who's administering your trust privately. They're also personally liable to creditors. Okay, but there's no probate process that we're clearing creditors. So what do we do as trustee? Do you all understand the dilemma? In a probate, when we're notifying the creditors and we're sending out notices and we're publishing notices in the paper, we've done the legal duties that we're required to do so that even if a creditor comes forth after the creditor's notice period has expired, which is 90 days from the date of publication, they're forever barred. They're forever barred. So we have little risk in a probate administration of a creditor coming up a year and a half later and asking for money after distribution. But what about a trust? Remember, there's no probate process. What does the statute say? The statute says that your trustee is personally liable for 2 years. Gosh, you guys are good. Or is it up here? Yeah, it's up there. Okay. Are they cheating? Or I think this crowd knows it. I think they know it. 2 years. So what does that mean? Do you hold the trust open for 2 years? Oh, dear me. I mean, that's a long time. Well, you can hold a reserve for 2 years, but you're going to have to file tax returns. What do you do? Well, if it's just like Jim and Joe and they're really good friends and good brothers and they trust one another, go ahead and make distribution. If something comes up, they'll both chip in, right? I mean, that actually works sometimes. But what we suggest sometimes, what we suggest to trustees is we can open up an empty probate, clear the creditors. We don't have to put all the assets through the court process. We just clear the creditors. So that's an option the family can choose. It's their risk. It's their risk tolerance, whatever they're happiest with. That's one of the choices that we're going to give them. Just open an empty probate. There's no inventory in the probate. There's no assets in the probate. But we can clear the creditors in 90 days as opposed to 2 years. So that's something that we just throw out there. Now, almost all corporate trustees, by the way, or people who are not also beneficiaries, are going to choose to do what? They're going to choose to do an empty probate because they are personally liable. They don't want to make distribution to all the beneficiaries and one day have to come out of pocket. So these are the trust administration problems that we have to deal with. The 2 years to clear the creditors. And that's a solution. Now what about the assets? What about the assets? Remember, Mike said we have to gather and value the assets. Whose job is that? Is that the lawyer's job? No. That's the personal representative trustee's job. Do your successor trustees or your personal representatives who you name their documents, do they know where all your assets are? Do they know how to get a hold of them? Do they know where you keep your account statements? More and more of you are doing things what? Online, right? What do you need when you log on to an online account? Username and password. Do your kids, if they're named as your personal representative trustees, do they know where to find those things? Do they? Yes? I'm hearing yes. Good. Okay. So it's whoever's named in your documents are going to be responsible for gathering and valuing the assets. We help them with that. But, you know, and those of you who are clients, you know that oftentimes we keep a record of what you have, and we have a maintenance program. We're asking you every year if you've acquired something different, opened a new account, we want to put it in your trust. But it's still a good idea so that someone who's going to be named in that capacity knows where to find them. We talked about the prudent investor rule in the sale of assets. By the way, it's a lot easier, by the way, to distribute cash than it is, you know, odd lots of stocks and stuff, right? Mutual funds. Just something to talk about with the family when someone passes. Now, what about the bills? What about the bills? A lot of times we get a question. Am I liable for my spouse's bills? Am I liable for my father's bills? Am I liable for my mother's bills? Generally speaking, the answer is no. No. There used to be something called the doctrine of necessaries in Florida. You all have ever heard about that? Where a man was responsible for his wife's necessaries. That was old common law, no longer in Florida. Now, if you're on a joint visa bill or something that you both signed and both charged on, chances are you're responsible for that. It's very unlikely that your children are. So even if you have big debts, we can usually clear those through the probate or trust administration process. And as Mike alluded to earlier, the homesteads can be cleared too. Homesteads, most of you here in Shell Point don't have a Florida homestead, but for those of you who do, those are usually not subject to claims of creditors. So you can have a $200,000 homestead without a mortgage and $300,000 of credit card bills, and the kids get the homestead and no one has to pay the creditors under Florida. So, with that said, we're going to go to taxes. And when it gets really hard, that's when I turn it over to Mike. So he gets to talk about taxes.
Thanks, Craig. Yeah, for some reason I always get the technical stuff. Taxes, we won't spend a whole lot of time. Good news in Florida on taxes is Florida has no state income tax, as we all know. Florida also has no state death tax or state estate tax. So Florida is a very, very tax-friendly state. Now, the converse to that is the bad news is we do have federal taxes that we're concerned about. So we do have federal estate tax for large estates, and what is large, it kind of fluctuates with whoever's in Congress and whoever the president is. But as of right now, we're shooting this in January 2011, and right now Congress just passed a new law, $5 million, $5 million per spouse. So that's fairly large. That takes a lot of folks off the tax roll. But like Craig alluded to earlier, we've got a 2-year window. So, they've made an election year issue, which is fine, but that's left us in kind of back to where we were with the Bush tax cuts. What's going to happen in 2 years? What's the law going to be 2 years from now? Hopefully we'll all still be around 2 years from now. So, remember, this isn't until we pass away that all of this is finalized, and we need to know what the law is going to be when we pass away. And income taxes. We do have federal income taxes. And the last thing about taxes that we do need to be concerned about is, remember I mentioned earlier when we own real estate in other states. We've got to be concerned about probate, ancillary probate in those states, of course, but also state estate taxes on the land, on the dirt that you own in that state. I've had a couple clients that in the last couple years they've owned Connecticut property and out-of-state property where they're actually having to pay state estate tax because of the way they calculate their exemptions and the way they do things. So some of my clients have said, you know what, I'm just going to sell my out-of-state real estate and rent when I get up there. That way we're not concerned about state estate taxes on the value of the land. Also know, some states like New York, for example, has $1 million state death tax credit. But also remember that that is for New York residents. They most likely will prorate it for non-New York residents. This is what happened to my Connecticut client. He had the real quick story, the value of the real estate was only a couple $100,000, and Connecticut had maybe $600,000, $700,000 exemption. But it was prorated based on the value of the total estate. So they didn't get the full $600,000, $700,000 exemption. They only got a portion of it, and they actually ended up owing state estate taxes on that. So just be careful. Anytime we own real estate out of state, not only the probate, but also potentially state estate taxes, and the estate plan needs to address that. Not just federal, but state estate taxes. Okay, so what about final distribution? After the accountings are filed, after the creditors are cleared, after everything has happened, we're ready to make final distribution. So we've got a couple different options. First off, specific bequests. These are, I leave $5,000 to each one of my grandchildren, or I leave $100,000 to so-and-so, off the top. These do come off the top before we make the remainder split among the other beneficiaries. There is an issue, and then outright distributions, just making it outright free of trust. There's a timing issue. Craig alluded to this a little bit ago. Do we make it soon after passing? Well, if we make it sooner rather than later, well, what if we've got a big expense or a big creditor that comes in and I've got to ask that beneficiary for the cash back? Well, okay, well maybe we wait till later, till after everything's happened. Well, the concern there is, well, what if the value's gone down and we don't have enough to satisfy all the bequests? So it's always it's something we need to have a conversation about and seeing, when should these specific distributions be made. We also talked about the continuing trust. In the married situation, we don't make distribution outright to the spouse. So it is not a final distribution. It's a distribution in trust for the spouse. And the spouse, as the trustee, will typically continue managing that trust for the rest of his or her lifetime. Same way with the kids. We want to make sure that, okay, it's final distribution as far as this trust is concerned, but it might actually create additional trust after we pass away. Very, very common. How much time? Typically, in our non-taxable estates, anywhere from 6 to 9 months. Like I said, that really is going to depend. If we do have an estate tax return to file, it could be as much as 2 years. We have to file the estate tax return within 9 months of date of death. We can extend that for an initial 6 months. So right there, you're already over a year in advance. IRS could take as long as another year to get back to us and actually issue our clearance letters. So it could be a very, very long process if we have a taxable estate. Also, if we've got a creditor or some type of dispute, a will contest or a trust contest, that can really, really delay the process. Actually, we had a client where the personal representative died in the process, and so we had to get a new one appointed, and so it just really delayed the entire process. But the key, though, is everything isn't frozen. We've talked a lot about making sure taxes are paid and making sure creditors are paid. We can still use the trust assets for the benefit of the family during this whole process and during this window. We just want to be smart in how we do it. We only want to make a distribution if it's absolutely necessary. We want our trustees and our personal representatives thinking about that before they just, okay, you need money, here, cut the check. We just want to be careful.
If I could jump in on that.
Yeah, sure.
We get this a lot. I bought a new house since Dad died, and I need my distribution now. I bought a new car. My business needs money. And there's a lot of pressure sometimes on your beneficiaries impose upon whoever's acting as your personal representative and your trustee to make early distribution. And sometimes it's the personal representative or trustee themselves who are trying to do that. So I bring this up so that you will think about who your personal representative or trustee is going to be, because they have to be fairly knowledgeable as far as, or at least trustworthy with regard to these issues, They also have to have a pretty thick skin, don't they? Because when your kids call and say, hey, I just bought a new house, you say, hey, I ain't dead yet. What do you think I'm responsible for, right? Sometimes, quite honestly, what I say to the beneficiary who's calling and quite angry that we're not through this process yet, I'll say, what would you have done if Dad hadn't died? See, you guys don't hear this stuff. We do. So I want you to think about that when you're selecting your trustee and personal representative.
Yeah.
Sorry.
No, that's great. Great point. And like Craig said, usually I tell the trustee and the personal representative, make me the bad guy. Say, hey, the lawyer won't let us do it. So they blame me and they talk to us about it as opposed to putting all the pressure on them. All right, so the last thing here, what about all these assets outside of the trust? We've got IRAs, we've got annuities, we've got life insurance, jointly held assets. Like Craig mentioned earlier, these are assets that pass outside of the trust administration, outside of the probate administration. Sometimes a good thing, sometimes a little problematic if it goes to beneficiaries that we didn't think about and that it wasn't coordinated properly because we were unaware of it. We can help with these assets. We can talk with the personal representative or the trustee about how best to do it. Especially with the IRAs, we've got stretch outs and all these different post-mortem planning things that we can do with these types of assets. But typically, these all pass outside of the administration. All right.
Okay, so we're almost done. Thank you. What I'm going to describe now, just so you know, and for purposes of the DVD, every law office handles their administrations different. What we use when we do ours with our clients and their families is something called the Estate Settlement Solution, which is that blue brochure you have, which is our unique process designed to minimize the stress of settling a loved one's estate by helping your trustee and personal representative delegate the legal, tax, and financial responsibilities to qualified and trustworthy professionals while still maintaining control because they're actually the one responsible for all of these decisions. So the way we do it, we have a process that we take people through. The first thing we do is what we call our organizer. Those of you who have been through our estate planning process are familiar with that. We just make sure that we help them organize and marshal all the assets so we can decide which assets are subject to probate, which assets aren't, which assets are in the trust, what assets might have beneficiary designations, which assets we're going to use to pay bills, and so forth and so on. So we organize everything with your trustee or personal representative to make sure that we have a good handle on that. Get valuations and those sorts of things so we know what the step up in tax cost basis is, or if there's an estate tax, we have to get valuations for that as well. The next thing we'll do is an advisor review. We'll ask your family, are they comfortable with all the advisors? Financial, legal, us, tax, CPA. By the way, I want to make this point. Estate tax returns and gift tax returns, it's a whole different area of the law than income tax returns. H&R Block might be perfect for you for your income tax return. Don't use them for your estate tax return. We're going to tell your family that. We want a qualified CPA. Now, by the way, I'm a CPA. I don't practice as one. I've held my license all these years. Early in my career, I worked for one of those big international accounting firms because they hired guys like me who had both degrees. But I don't do tax returns. We don't do them. We work with whoever your family works with. Might be a CPA up north, might be someone here that we can recommend if your family isn't comfortable with who's acting. The next thing we'll do is a goals conversation. You might want to look at this inside your brochure. There's a page, it's like the third or fourth page in. This is something that we're happy to go through and ask the family. Do you understand the will and trust? We'll walk through them if they need us to. Are there multi-tiered beneficiaries? Who has a position of authority? What happens if they can't act? Like Mike described, we had a trust administration where the trustee died halfway through. Are there opportunities to save taxes? Mike talked about something called post-mortem planning. Kind of a not a nice term sounding, but there are things we can do after the fact to save taxes potentially. So we'll talk about that. So there's a whole list of items in the goals conversation that you might want to look through. Those are the sorts of things that we're going to go through with your family. The legal manager is really setting up everything so that we know what process we're using. Is it a probate process? Is it a trust administration process? Is it an abbreviated process? Are we going to clear creditors through an empty probate? All of those sorts of things. The financial coordinator, we're going to need to know the step up in tax cost basis. We need to know the date of death values. We need to decide whether we're going to liquidate assets to make sure that we follow the prudent investor rule so we're not in volatile assets during the short administrative process and so on. Tax coordinators, usually working with whoever your CPA is or somebody who's preparing the tax returns. Make sure the personal representative trustee has to be communicating with that person to make sure that they know what's going on because there's various tax elections that have to be made. The new beginnings process speaks to updating your will and trust. Oftentimes this is very important for surviving spouses because their trust might need to be updated now that their spouse has passed. Or even the children. Just to give you one example, sometimes you leave each other something called powers of appointment. Allows your children or your surviving spouse to appoint different beneficiaries than what you have in your trust. That's to, if circumstances change in the family. So that might be a reason to review the surviving spouses or the children's estate planning documents. Obviously, if those individuals live somewhere else in a different state, they're going to want to do that with their attorney in that state. So that's the process we usually take them through. We named it and processed it so that everybody would have a good idea of what to expect. Something very interesting I hope you find that's also in your packet. I co-authored a segment of a book written by Wealth Council, which is a national network of estate planning attorneys. You'll find it in your package. It's entitled Trust Administration to Reduce Estate Taxes. It's actually misnamed. The purpose of this chapter wasn't really to talk about estate taxes. It's really to talk about the trust administration itself. And it's kind of a nice review of everything that Mike and I have talked about today. So we give that to you in your packet. So with that said, we have a few minutes. And those of you who have questions, why don't you ask them? We'll take a few minutes of questions and we'll let you all go.
In the 2-year period that you have to satisfy creditors of the trust, are there creditors out there who are out to scam by coming up with phony claims?
Yeah.
And what are these kind of people?
The question was, I'm going to repeat the questions because, for purpose of the tape, are there predators who will file phony claims? Well, here's the thing. In the empty probate or probate process, we can flesh those out. And here's what you do. When someone files a claim that we don't think is correct, we object to the claim. And then they have a period of time, 30 days, in which to file a lawsuit against the estate, and then we can settle it if it requires settling. But that's a benefit of doing an empty probate and a trust administration, because we have a legal means to flesh out those claims. And sometimes they're well-intentioned claims, but they're just wrong. Like I have one right now where we have an alimony dispute. He still owed me X number of dollars of alimony when he died. We say, no, we have these canceled checks. So, those are issues that come up.
Please redefine both your personal representative and trustee, and can they be the same person?
Yeah. Redefine personal representative and trustee, and can they be the same person? Your personal representative is the executor under your will, and they're the person who will be named to get letters of administration through the court to act as your executor. Your trustee is the next named person in your trust after you, if you're either incapacitated or you die, to carry out the terms of your trust, to settle your trust estate. And yes, they can be the same person. Yes?
If you have a trust, does it avoid probate?
Great question. We get that a lot. The question is, if you have a trust, will you avoid probate? And the answer to that is no. Having a trust is not enough to avoid probate. We didn't really talk about funding much today, but this is a big pet peeve of mine. A lot of clients will come in and they'll have a wonderful trust. It may be up north and we've got to restate or we've got to make some tweaks. But what they haven't done is they still own everything individually. They still own things in their individual name. They haven't taken the time to actually put it into their trust, retitle their asset out of Michael Hill individually into the Michael Hill Trust. And so a lot of attorneys do disservice when they set up the trust and don't explain the probate or don't explain the funding process. That's one of the things that we do. Absolutely. You can. You set up, it's a two-step process. You set up the trust. Okay, trust is good. We want the trust. And then you have to put your assets into the trust. Okay, because if I have a trust and I own all my assets individually, I'm going to have a pour-over will. If the attorney did their job, you're going to have a pour-over will that will take your assets and pour them into your trust at your death. But the problem is that pouring over is a probate. And so it requires the probate process to get the assets into the trust. So one of the things that we really, really stress to our clients is fill out your organizer. Let us know what all assets you have, what all bank accounts, even the small checking accounts. The ones that revolve and you only have $1,000 a month in it each month. Those are all important because those are little probate assets if we don't actually get them into our trust. So no, trust is not necessarily enough. It's a two-step process. Create the trust, put your assets into the trust.
Yes, sir.
If you name a personal representative, a relative, who is a resident of a foreign country, under Florida law, do they qualify?
The question is, if you name as your personal representative a resident of a foreign country, do they qualify as your personal representative? How many people think yes? How many people think no? How many people don't want to raise their hand because they fear they're going to be foolish?
It depends, right?
I love doing that. No, if they are legally qualified, and usually anyone who is related to you either by blood or by marriage, usually is legally qualified, doesn't matter where they live, they can act as your personal representative. Under Florida law.
Yeah. The problem
That's
is
right.
if you've got a friend or...
a friend who lives in Norway, probably not.
Right. Yeah. They'd have to either be a Florida resident or a relative.
Now let's go in the back.
How firm is the $75,000 that you're talking about?
Actually, I think it might be 50. I think we might be wrong on that.
No, it's 75.
It's 75?
75 for summary. Used to be 50.
I use.
No, it's 75. It's firm. You know, if you've got $75,001 in your estate, you do not qualify for summary administration.
Yes, sir.
I'm a new resident in Shell Point.
Okay.
My legal documents were written in the state. Are they transferable to Florida, or do they need to be?
Talk about our video out there.
Well, one of the things that we've got outside is our Florida residency. The question was if new Shell Point resident still documents out of state. We see this a lot, even for people who aren't so new. They just haven't taken that step to update. We've got a video outside. It's called a Florida Residency Guide and DVD, and it's about 15 minutes that walks you through the process of why it's important to update your estate planning documents. No, not necessarily. Florida has some really quirky laws dealing with homestead and some other things that usually require some type of update whenever people come down. We don't want to just rely. Yeah, here's a sample of it. So it's real quick, a little brochure, about 15-minute video that goes into all of those, and we can talk afterwards.
One more question, and then we'll stay afterwards. Yes, in the back.
Can you have personal representatives and trustees?
Yeah, good question. Can you have co-personal representative and trustees? Yes, you may. Sometimes, and again, it's a drafting and a counseling issue. Does it require both of their signatures? If you've got two, do you require both of them? Can they act independently of each other? What if they are tied and they're deadlocked? Well, if they can't decide, well, basically they can't do anything without a court jumping in. So sometimes the answer is yes, you can have it. But does it really make sense? Should you have it? Boss me?
Okay.
Okay, that's it.
Thank you. I don't think this is tied into the house system. Thank you for being a part of this. I hope that it was helpful. Craig and Mike will remain afterwards for just a little bit in order to answer any personal questions you have. We value your feedback and would appreciate having that evaluation form. In February, we'll be having another seminar. We'll hope to see you then. Thank you.
Thank you all very much for your time.